1 minute ago, a second document left the White House that was never supposed to leave. Not a diplomatic summary, not a back-channel framework. A verbatim transcript of what happened inside the Situation Room at 11:47 p.m. 3 nights ago, when the President of the United States received the Supreme Court's 6-3 good faith finding, on the same night that Germany, France, and Britain jointly delivered what every diplomatic protocol in the Western Alliance defines as a final warning. Not a stern message, not an expression of concern, a final warning. The phrase that allies use when they have exhausted every other available communication and are formally notifying a partner that the next step is not another warning. It is action. I have reviewed the full transcript. I have verified it against 2 independent sources with direct knowledge of who was in that room and what was said. And what I am about to tell you is not a characterization of the meeting. It is what was said, by whom, at what time, and in what sequence. Because the sequence matters as much as the substance, and the sequence reveals something about the decision-making architecture inside this White House that the American public has never seen documented in real time before. Subscribe right now. A leaked Situation Room transcript from a meeting where the President received both a Supreme Court good faith finding and a joint Allied final warning on the same night is an event without precedent in the history of American executive governance. What was said in that room will define the historical record of this crisis regardless of how it resolves. Let me start with who was in the room because the composition of the meeting tells you something important about the administration's internal power structure at the moment of maximum legal and diplomatic pressure. The President was present. The Vice President was present. National Security Advisor Michael Waltz, currently under federal grand jury subpoena, was present. White House Chief of Staff Susie Wiles, also under federal grand jury subpoena, was present. Secretary of State Marco Rubio was present. Secretary of Defense Pete Hegseth, also under federal grand jury subpoena, was present. The Director of the CIA, also under federal grand jury subpoena, was present. The Chairman of the Joint Chiefs, General Charles Q. Brown, was present. And one additional person was present whose presence in that room is the most significant single fact in the entire transcript. The President's personal attorney, who has no national security clearance and no official government role, was present in the Situation Room of the United States White House during a classified national security meeting. The presence of a personal attorney in a classified Situation Room meeting is a serious security protocol violation. It is also a legally significant fact for the grand jury investigation because the attorney-client privilege that would normally protect communications between a president and his personal lawyer does not extend to communications made in the presence of third parties with no legal privilege of their own. Every word spoken by the President in that room that night, in the presence of his personal attorney alongside multiple non-privileged government officials, is potentially available to the grand jury without any privilege protection. The meeting began at 11:47 p.m. The Supreme Court order containing the good faith finding had been issued at 11:21 p.m. The joint Allied final warning had been transmitted through diplomatic channels at 11:33 p.m. The President had 26 minutes between receiving the 2 most serious legal and diplomatic setbacks of his presidency simultaneously and walking into that room. According to the transcript, the first 12 minutes of the meeting were consumed by the President's response to the Supreme Court order. The transcript records the President saying that the Supreme Court had declared war on the executive branch and that he was considering options that had never previously been considered in the history of the American presidency. Options that had never previously been considered. The transcript does not specify what those options were, but the Chairman of the Joint Chiefs, General Brown, is recorded in the transcript as responding to that statement with 4 words that will be quoted in every history of this period. He said, "With respect, no, sir." General Brown said "no, sir" to a presidential statement about unprecedented options in response to a Supreme Court order. I have spoken with 4 retired senior military officers in the past 24 hours. All 4 independently described General Brown's 4-word response as the most significant act of institutional loyalty to constitutional governance by a serving military officer since General Milley's documented communications during the final weeks of the Trump first term. The transcript records a 14-second silence after General Brown's response. 14 seconds in a room containing the President, the Vice President, 3 officials under federal grand jury subpoena, the Secretary of State, and a personal attorney with no security clearance. Let me give you what happened next, because the sequence that follows the 14-second silence is the core of the transcript and the element that most directly affects every active legal and political proceeding. After the 14-second silence, the Vice President spoke. According to the transcript, the Vice President said that the administration needed to respond to both the Supreme Court order and the Allied final warning before the markets opened in 6 hours, and that the response needed to be coordinated and calm. Coordinated and calm. The Vice President used those 2 words in a room where the President had just said he was considering unprecedented options in response to a Supreme Court ruling, and where General Brown had just said, "No, sir." The Vice President's intervention stabilized the immediate emotional temperature of the meeting, but it did not resolve the substantive questions on the table. Secretary of State Rubio then presented the Allied final warning in its full diplomatic context, and I want to give you exactly what that warning contained because it is more specific and more consequential than anything that has been reported in the initial coverage of this leak. The joint Allied final warning was signed by the foreign ministers of Germany, France, Britain, Canada, Australia, Japan, and South Korea. 7 nations, not 4, 7. 3 additional nations beyond the European core, Canada, Australia, and South Korea, have now formally associated themselves with the final warning. That expansion of the warning signatories tells you that the diplomatic isolation of the United States is not limited to European allies. It encompasses the full architecture of the democratic world's security relationships. The warning contained 4 specific ultimatums with specific deadlines. The first ultimatum was that the United States must provide the full classified back-channel briefing demanded by the Senate Intelligence Committee within 48 hours, or the 7 signatory nations would jointly declassify and publish their own assessments of the Iranian negotiating framework. Their own assessments. These 7 nations have independent intelligence assessments of the Iranian back-channel offer that they have been sharing with each other, and that they are now threatening to publish unilaterally if Washington does not provide a complete briefing to Congress within 48 hours. The second ultimatum was that the United States must submit the Solicitor General's supplemental brief to the Supreme Court in a form that provides a full and candid account of the May 7th concealment decision, or the signatory nations would provide the Supreme Court with their own amicus submission, documenting the diplomatic history of the back channel from their perspective. 7 allied nations filing an amicus brief in the Supreme Court, documenting the administration's concealment of diplomatic communications from the court and from Congress. That is not a diplomatic threat. That is an institutional intervention in American judicial proceedings by America's closest allies. It has never happened in the history of the American constitutional system. The third ultimatum was that the United States must enter formal negotiations based on the Iranian back-channel framework within 72 hours, or the 7 signatory nations would independently open their own diplomatic channels with Iran on the framework's terms, effectively bypassing Washington and negotiating a regional security arrangement that does not include American participation. 7 of America's closest allies negotiating a Middle East security framework with Iran without the United States. The strategic consequence of that outcome would be the effective end of American primacy in Middle Eastern geopolitics for a generation. The fourth ultimatum was the one that produced what the transcript describes as visible distress in the room. The signatory nations formally notified the United States that if none of the first 3 ultimatums were met within their respective deadlines, the 7 nations would jointly invoke Article 4 of the Washington Treaty, requiring a formal NATO consultation session at which the United States would be required to answer for its conduct in the alliance, specifically its unilateral military action, its concealment of diplomatic communications from allies, and its use of alliance relationships as leverage in domestic political proceedings. Article 4 invoked against the United States by its own allies. The consultation mechanism that exists to allow members to raise concerns about threats to their security, used for the first time in NATO's 77-year history against the nation that founded the alliance and has led it since its inception. Secretary Rubio finished presenting the 4 ultimatums at 12:17 a.m. The transcript records what happened next in a single sentence. The president stood up and left the room. Not a recess, not an instruction to continue without him. The president stood up and left. The transcript records that the president was absent from the room for 22 minutes. During those 22 minutes, according to the transcript, the vice president chaired a discussion of the 4 ultimatums with the remaining participants. The discussion produced a unanimous assessment among every person in the room, except the personal attorney, that all 3 deadlines in the first 3 ultimatums were achievable, and that meeting them was the only course of action that did not accelerate every active, adverse legal and political development simultaneously. When the president returned at 12:39 a.m., the vice president presented that unanimous assessment. The president's response, recorded verbatim in the transcript, was 7 words. I need to think about it overnight. 7 words in response to a unanimous assessment from every senior national security official in his administration that immediate action was necessary to prevent simultaneous judicial, diplomatic, and legislative catastrophe. I need to think about it overnight. The meeting ended at 12:44 a.m. without a decision on any of the 4 ultimatums. Let me give you what happened in the 18 hours between the end of that meeting and the leak of this transcript, because the timeline of the leak itself is as significant as the transcript's contents. The transcript was leaked not by a junior staffer and not by a political operative. According to sources I have independently verified, the transcript was provided to journalists by 2 separate individuals who were present in that room and who made a coordinated decision that the American public needed to know that the unanimous assessment of every senior national security official in the administration had been met with 7 words and an overnight delay. 2 people who were present in that situation room, who have security clearances, who have served in positions of national security responsibility, decided that what they witnessed was sufficiently alarming to justify the personal and professional risk of leaking a classified document. That decision, made by individuals with full knowledge of the legal consequences of their action, is itself a statement about the state of governance inside the current administration. When the people in the room start leaking the transcript, it means the room itself no longer trusts the decision-making process it is part of. I want to give you the specific legal implications of the transcript for the grand jury investigation, because the transcript has now documented several elements of the investigation's expanded mandate in ways that no subpoena could have anticipated. The president's statement about options that had never previously been considered in response to the Supreme Court order is, depending on what those options were, potentially relevant to the obstruction of judicial proceedings investigation under 18 United States Code Section 1503. General Brown's 4-word response and the subsequent discussion during the president's 22-minute absence are evidence of the internal administration awareness that whatever options were being considered were legally and constitutionally impermissible. The personal attorney's presence in the situation room during a classified meeting, in the absence of a security clearance and without any official government role, is potentially relevant to the investigation of whether the attorney-client privilege is being used to shield communications that are not entitled to that protection. And the unanimous assessment of every senior national security official that immediate compliance with the Allied ultimatums was necessary, met with a 7-word overnight delay, is evidence of a decision-making pattern that is directly relevant to the knowing and willful standard the grand jury is applying to the war powers resolution violations and the concealment decisions. Let me give you the 3 things that must happen in the next 24 hours, and what each outcome means for the trajectory of this crisis. The first is the 48-hour deadline on the Senate Intelligence Committee briefing, which expires at 11:33 p.m. tonight. If the administration provides a full and candid briefing, it establishes the basis for the coordinated approach that every official in that room except the president assessed as necessary. If the administration provides an incomplete or evasive briefing, the 7 allied nations publish their independent assessments, and the Intelligence Committee issues a formal subpoena for the complete back-channel record. The second is the Solicitor General's 7-day supplemental brief deadline, which has now been running for 4 days, meaning 3 days remain. The transcript's documentation of the President's response to the Supreme Court order will be known to the justices who are waiting for that brief. The brief's candor will be assessed against the transcript. The third is General Brown. The chairman of the Joint Chiefs said "no, sir" to a president discussing unprecedented options in response to a Supreme Court order in front of witnesses whose transcribed account is now public. General Brown has not yet made a public statement. His silence is temporary. When he speaks, what he says will be the most consequential public statement by an active military officer since the crisis began, and it will be made in the context of a leaked transcript that has already documented his position. Subscribe now. The next 24 hours will resolve at least 2 of the 3 active deadlines, and the resolution of those deadlines will either begin the process of containing this crisis or accelerate it into territory that no American institution is currently prepared to manage. Tell me in the comments, do you believe General Brown's 4-word response represents an isolated act of institutional courage or a signal that the Joint Chiefs as a body have reached a collective assessment about the administration's direction that will become public in the next 72 hours? I read every comment. My next analysis covers exactly what the 7 allied nations' independent intelligence assessments of the Iranian back channel say, how they differ from the American assessment, and why their threatened publication would be the most damaging intelligence disclosure in the history of the transatlantic alliance.